Straight ahead on Law&Crime Daily. The family of a college student missing for 2 decades now suing the father of her alleged murderer. Why Kristin Smart's parents think Ruben Flores knows where the remains of their daughter is. And the U.S. Supreme Court ruling changing courses on how juvenile offenders are sentenced. Should minors convicted of murder automatically be sentenced to life in prison without parole? Plus,
I am guilty, Your Honor.
The Ohio man admitting his family killed 8 members of another family in the Pike County Massacre. And we speak to the family of George Floyd about the funeral of Daunte Wright. 2 families' quest for justice in Minnesota.
Helping, changing, seeing the light that we didn't see before.
Law&Crime Daily, covering court cases from coast to coast.
And welcome to Law&Crime Daily, everybody. I'm Jesse Weber, in for Brian Buckmire, along with co-host Terri Austin. The 20-year-old man killed by a police officer near Minneapolis during the Derek Chauvin trial was laid to rest. Brian Buckmire was at his funeral for us and has the latest.
Days after the trial where Derek Chauvin was convicted for murdering George Floyd, we went to a funeral for Daunte Wright. At the funeral, many members of his family spoke: his mother, his father, his siblings, as well as Reverend Al Sharpton and attorney Benjamin Crump. They spoke about justice, accountability, and the life of Daunte Wright.
When he walked in the room, he lit up the room. He was a brother, a jokester. He was loved by so many. He's going to be so missed.
But we also saw somewhat of an indoctrination into this fraternity of individuals who have lost loved ones at the hands of police. The family of Philando Castile was there. The family of George Floyd was there. Kenneth Walker was there. The family of Emmett Till were there. Everyone who has been touched in a similar way in loss and love was there to show support for the family of Daunte Wright. Afterwards, we had the opportunity to speak with George Floyd's uncle, who spoke about being an activist not only for his nephew, George Floyd, but for all people.
The verdict, we got the one that we needed. Did we get the charge that we needed? No, but hey, listen, it's something, you know. He don't get to walk around anymore. For the first time, we finally get an opportunity to see that we can win this battle and fix this battle. But the momentum my nephew gave us at his death, it's pretty good. We had a jump start, you know, and as long as we keep on fighting the way we're fighting and people get their head up and just make good decisions, we will be okay.
Now the family and the community is looking for justice as they seek a guilty verdict from former officer Kim Potter, but they're saying that manslaughter is not enough. They're looking for higher charges and will push for those charges as well as greater justice for their community and their country abroad.
All right, thanks, Brian. Derek Chauvin could be facing federal criminal charges on top of his state conviction. Law&Crime's Angenette Levy's here with the latest turn in this case. Angenette?
Well, Jesse, this is an interesting development that's come out. ABC News is reporting that Department of Justice sources are telling them that they're looking into another incident involving Derek Chauvin in which he pinned a boy to the ground, a 17-year-old boy, with his knee.
Prosecutors say body camera footage shows Derek Chauvin kneeling on the boy's back for 17 minutes. Police were called to the boy's house after his mother said she was assaulted by him and her daughter. The boy reportedly was laying on the ground when officers arrived and would not get up. 2 seconds later, Chauvin grabbed the child's throat and hit him again in the head with his flashlight. The boy cried out, "Mom," and appeared to lose consciousness. He awoke about a minute later and said he couldn't breathe as Chauvin kneeled on him. There's also a civil investigation underway by the Department of Justice into the practices of the Minneapolis police. It's something activists here have been asking for years.
We reminded them of what their purpose was. We let them know that there are people here that are hurting, that there's people here who are dying, and we most importantly let them know that we needed their help, and they needed to be right here with the people.
As part of that civil probe, federal investigators will be looking for input from the public. That investigation could take as long as 2 years. Jesse?
Thanks, Angenette. Now let's break it down. With us is retired NYPD detective and New York Law School professor Kirk Burkhalter and Terri Austin. Terri, the state attempted to admit the September 2017 incident during the trial phase of the case. It wasn't, but do you think that this incident will be raised during the sentencing phase of the case?
I do, Jesse, because they have wider latitude during the sentencing phase. And the last thing the judge asked about was, I want you to give me the aggregating factors. And of course, he's going to consider the mitigating factors because he's going to be looking at the sentencing guidelines. And I think that when he looks at all of those factors, he looks at what has happened in Chauvin's history. He's going to consider everything. And at the end of the day, I believe he's going to impose the maximum that he possibly can under Minnesota law, which is that second-degree murder count up to 40 years. It may be less than that, but I think he's going to try to get as much as he can.
Now, Professor, what charges could Chauvin potentially face for the 2017 incident, and does the guilty verdicts in Floyd's case affect this at all?
Well, and on the federal level, this would be a deprivation of civil rights. And what we have seen is these cases are difficult to bring against police officers. However, Derek Chauvin is a different animal because you already have this pattern of behavior. So if you can use the problem with the death of George Floyd, the Floyd case is that this occurred after he did this allegedly to this child. So may not be able to come in. Usually you'll see some type of prior act to come in to show a pattern.
All right, and Angenette, real quick, what's the feeling amongst activists about this civil investigation?
I think they're hopeful, but also skeptical. They will tell you, if you speak with them, that the Justice Department was here back in 2016 at their request, and they arranged meetings between the activists and the police department. There were working groups, but the activists say any reforms that came up or were outlined in paperwork were put in a file and it never went anywhere. So they're hopeful, and they say this time they want less talk and more action.
Well, I think we all knew that those guilty verdicts wasn't going to be the end of the story, and it's going to be a story we continue to follow. Still ahead on Law and Crime Daily, a new lawsuit in the case of missing college student Kristin Smart. An update to this 24-year-long saga. But first, a major break in Ohio's largest murder case, the deadly custody battle, and why a man says he's flipping on his own family when we come back. Welcome back, everybody. A major development in Ohio's largest ever murder investigation. One of the 4 people charged in the Pike County massacre admits he and his family committed the crimes. Angenette Levy's back with the latest in this saga. Angenette?
Jesse, for many years, Jake Wagner and members of his family have vehemently denied any involvement in the Rhoden and Gilley murders. But now that has changed.
Yes, Your Honor. I agree to what the state has provided, and I'm deeply and very sorry.
On the 5th anniversary of the Rhoden and Gilley murders, Jake Wagner stood in a Pike County courtroom and admitted he and his family killed the 8 family members, including the mother of his child, Hannah Mae Rhoden.
What plea do you wish to enter in count 7 to the charge of aggravated murder of Hannah Mae Rhoden?
I am guilty, Your Honor.
Wagner appeared to tear up when Hannah Mae's name was mentioned. Prosecutors say Wagner, his mother Angela, father Billy, and older brother George wanted full custody of the little girl Hannah and Jake shared. He recently confessed to state investigators after years of denying involvement.
What he told us led us to discover some evidence that had yet to be recovered, specifically the weapons that were used in these offenses, along with vehicles that were used during these offenses, including one that was bought specifically to use the night of the homicides.
Wagner and his family were indicted in November 2018 after a 2.5-year investigation that included pleas from Geneva Rhoden, the matriarch of the family.
I'd just like to say from my mother's heart that I hurt so bad inside from the day that I found out
At the start of the investigation, there were few leads. Then investigators' attention turned to the Wagners a year after the murders.
This was cold, cold, cold blood. I mean, this was calculated, planned out.
Ohio Governor Mike DeWine was the Attorney General when the murders happened. That day, he promised the Rhodens the case would be solved.
Family's been through hell. While today I'm sure was a very gratifying day, it couldn't have been an easy day. They've got to be leaving here just totally exhausted and emotionally spent. But these are tough people. These are strong people.
And as part of the plea agreement, Jake Wagner has actually agreed to testify against his mother, his father, and his older brother. And the death penalty as part of the plea agreement has been taken off of the table for all of them. Jesse?
Wow. All right. Thanks, Angenette. Let's bring back in our panel. Professor, so Wagner pleads guilty. The death penalty is taken off the table, apparently, for all of them. Is that justice?
I guess it depends on your view of whether the death penalty is an appropriate penalty at any point. I will say it may be justice for the family because it could possibly save them the pain of a very long trial with all types of testimony that would be wildly uncomfortable for them. So it very well might be.
You know, Terri, how do you think Jake Wagner's guilty plea is going to affect the cases against his other family members? And you talk about family drama, my gosh.
Absolutely. You know, I think this is really obviously going to help the prosecution because they initially were going off in tangents. Now they have someone who is cooperating. They have someone who can give them specific evidence. They don't have to worry about getting this conviction because clearly he is talking and he is going to confess as far as the others are concerned. So I think it's going to save the state money. I think it's going to save both families, obviously, time to deal with this issue. And it's going to help the community because for many years, people have been wondering what is going to happen in this case. It was one of the most horrific crimes I think anyone has seen. This was a huge massacre. And to have everything solved now, I think is really going to help all around.
Angenette, I know you've been following this case, and the governor said this was well planned. What do we know about that? And also, why did Wagner decide to confess?
Well, first of all, part of the reason the governor says it was so well planned was because the Wagners, apparently, according to Jake and according to the state agents, had hacked into the Facebook accounts of some of the Rhodens and actually were monitoring them in their homes through surveillance cameras. So this was very well planned from the aspect that Hannah Rhoden in a Facebook message months prior to the murders said to somebody, to get my child, they're going to have to kill me first. And then after that, the governor and the state agents say that Wagner said they began to plan the murders. They bought bullets, they bought shoes, they bought guns, they bought vehicles. And Wagner says he found God. That is why he confessed to the murders.
Wow. Classic. This case just keeps on coming. All right, coming up on Law&Crime Daily, the new Supreme Court ruling making it easier to sentence juveniles to spend their lives in prison. Plus, the trial of the only officer charged in the Breonna Taylor case now delayed. We'll tell you why, coming up. Supreme Court ruling will pave the way to make it easier for juveniles to be sentenced to life in prison without the possibility of parole.
The nation's highest court ruled 6-3 that juveniles don't have to be found to be beyond rehabilitation to receive the maximum sentence. It's part of the state of Mississippi versus Brett Jones. Jones was convicted and sentenced to life in prison without parole for stabbing his grandfather to death when Jones was 15 years old. Jones was arguing that he was not beyond rehabilitation and should be eligible for parole. The state of Mississippi said the Eighth Amendment, which protects against cruel and unusual punishments, doesn't require that burden. In 2005, the Supreme Court abolished the death penalty for minors, and in 2012 ruled that life without parole sentences for juvenile offenders should only be in the rarest occasions. Justice Brett Kavanaugh wrote the majority opinion issued Thursday, saying it was enough that the judge presiding over Jones's case exercised discretion rather than automatically applying life without parole.
Okay, Professor, legally, how did the court come to this decision? What was the justification?
Well, to be quite frank, the justification is that the Eighth Amendment does not state that the internment of juveniles for life is cruel and unusual punishment. This is an interpretation of the United States Constitution and an interpretation of how the law has been applied. So quite simply, it depends on whether you're a right-leaning judge or a left-leaning judge as to whether the law has been applied here or whether you have the power to do so. The discretion still lies with the lower court, and that's what the court is saying. So it's a very interesting decision.
And it's interesting you talked about it on political lines because Terri, Justice Sonia Sotomayor wrote a scathing dissent. What did you think of her opinion? What did she say?
I actually agreed with her opinion, and she wrote that on behalf of the other, left-leaning justices, and that would be Breyer and Kagan. And what she said is that the court had in the past been recognizing the fact that children are constitutionally different from adults for the purposes of sentencing. And that 2012 case you mentioned, Jesse, it really said that the Constitution should be a bar for children being punished for mandatory sentences like that if it's cruel and unusual punishment. And one of the things she mentioned in her dissent was that 70% of all youth who receive this sentence are children of color. So it makes you really want to think about what the criminal justice system is doing as far as applying these standards.
It's an interesting decision, and it's also going to be interesting to see how it ultimately plays out. When we come back, the family of Kristin Smart filing a new lawsuit and new allegations. Will the remains of the missing college student ever be found? Stay tuned. Welcome back, everybody. We want to tell you about our latest show on the Law&Crime Network called Prime Crime. It's part 2 of our story on Samuel Little, the most prolific serial killer in United States history. We get into his background, motivation, psychology, relationships with women, and we also ask the people who interviewed Little, what was it like to sit across from a murderer?
I'll just say that when you see his hands, you'll see just how monstrous they are. He may still murder that person, even though he was 70 years of age. If he felt he could get away with it, he would.
Did you ever shoot any of these girls?
Shoot?
Yeah, with a gun?
My hands.
Just your hands?
And without that, I wouldn't want to do it.
Plus, how investigators are confirming his killings, and is he responsible for more deaths that we don't know about? Tune in to Law and Crime. Well, let's focus right now on the trial for the former Louisville officer charged in the Breonna Taylor case, because that has been delayed until 2022. Brett Hankinson is facing 3 felony charges of wanton endangerment for shooting into a nearby apartment during a raid on Taylor's home last March. Now, no one is charged with Taylor's death, and the judge previously denied a motion by the defense to change the trial to another county. Now, that same judge is agreeing to postpone his trial that was scheduled for this September until February of next year.
I believe so. As I said, looking ahead to who I have in custody to be tried, whose trials have been delayed because of the pandemic, I think February 1st is the most realistic date that I have. That'd be fine. Okay. All right, then. We will take the case off of the docket for August 31st and reschedule the trial to February the 1st.
Over now to California, where the family of a college student missing since 1996 is now suing the father of her alleged murderer. Cal Poly State University student Kristin Smart seemingly vanished 24 years ago after leaving a party. Her ex-classmate Paul Flores is now charged with murdering her. His father, Ruben Flores, is charged as an accessory for allegedly helping to hide Smart's body. Smart's body has yet to be recovered, but her parents are now alleging in a lawsuit that Ruben Flores removed her remains from his home just days after the San Luis Obispo County Sheriff's Department served him a search warrant. Now, that happened that past February. Smart's parents are suing for severe emotional distress. And let's talk about it. Professor, how will this civil lawsuit affect the criminal case and vice versa?
I'm always a little skeptical because when you see this occur, usually you see the civil case follow the criminal case because the standard of proof, the bar is lower. So I wonder if this has something to do with a certain lack of faith or whatever in the prosecution as far as how it will affect the case. Once again, might create a little bit of a problem because of the testimony and evidence that is presented in the civil case. Prosecution will not have the first bite at the apple, so to speak. So that will be interesting to watch to see how that develops.
Yeah. Now, Terri, so Kristin Smart's family is suing for severe emotional distress. Have you seen this before, and what are the chances for recovery with this kind of claim?
You know, Jesse, it is fairly common to sue for intentional infliction of emotional distress. It's a tort claim. And I think their chances of recovery are high. I mean, you only have to show that the defendant intended to inflict this distress, or it was reckless, and that the conduct itself was outrageous, and that it did, in fact, cause emotional distress. And there's no question that there has been emotional distress. Usually you have to prove that distress with medical records, et cetera. But I think the parents are going to be able to prove it just with their testimony. And hopefully they will be able to recover. The question is, will there be funds to recover?
And we talk about the civil case, the criminal case. I think at the end of the day, we all agree, can we get more answers about what happened to this missing girl? That's really where we're all starting there. Professor Terri, thank you so much. And everyone out there, thanks for joining us here on Law and Crime Daily. We're going to see you next time as we discuss justice in America.